There's no allegation that my client's been drinking. There's no allegation that he has been under the influence of anything.
We are on for a review of the child visitation per Judge Brown's order of December 10th, 2024. I have reviewed the file to try to get up to speed on it, but I certainly would welcome counsel bringing to my attention anything relevant that I need to know at this time. The parties want to make an opening statement. Ms. Park.
I can do that, Your Honor. In preparation for today's hearing, Respondent's counsel and I've had some communication. I think we are mostly in agreement about how to proceed from today, but there is one issue that I think we'll need the court's assistance with, which is that my client would like the respondent to submit to breath testing at the beginning and ending of his visits with the children. And I think that the respondent is agreeable to that, but he wants that to be time limited, and we're not comfortable with putting a time limit on it at this point. So I think that's going to be primarily what we'll ask you to weigh in on today. But I did prepare just a brief timeline of kind of what has happened in the case for your benefit, Your Honor, and I will try to go through that as quickly as possible, as I know you've already reviewed the divorce file. But as the court knows, this petition, the petition for divorce was filed in October of 2018, and just a few days after that, on October 22nd of 2018, the respondent was charged in Ellis County District Court criminally in case 18 CR 494. His charges that were initially lodged against him were aggravated criminal sodomy, aggravated sexual battery, and 2 counts of misdemeanor domestic battery. The petitioner was the victim, and witnesses listed on the complaint were the parties' children, Brinley and Lola. The respondent entered into a journal entry of plea and sentencing on April 10th of 2019. He entered an Alford plea to 8 counts of misdemeanor battery, and he entered a no contest plea to 1 count of domestic battery. He was placed on 24 months corrections supervision with batter's intervention program. October of 2019, the parties reached an agreement, their separation agreement, parenting plan. Divorce was granted at the end of the month on October 23rd, 2019. Kind of the next significant action in the case was in January of 2020, the Ellis County Attorney's Office filed a motion to revoke the respondent's probation for him being unsuccessfully discharged from batter's intervention. That was followed in February of 2020 with an order for the defendant to find, enroll in, and complete a batter's intervention program at his own expense, which the respondent did. He was released from his probation April 12th of 2021. Then the next significant action was in the divorce case, January 19th of 2022, Megan filed a motion raising primarily alcohol-related issues. The parties were able to agree, and that's when the parties entered into an agreed order in February of 2022 for the respondent to submit to breath testing. That was kind of the first instance of that happening. By that summer, June of 2022, we filed a renewed motion making additional allegations that were alcohol related. And in September of 2022, the respondent was arrested for DUI. We entered into another agreed order that was filed January of 2023, which restricted the respondent's parenting time to therapeutic and supervised, and also reiterated the breath testing requirements and required his attendance at Alcoholics Anonymous and to report his attendance in those programs. There was also a subpoena issued for the respondent's bank records, and that was heard by the court February 22nd of 2023, the court ordered the respondent to produce his bank records after the respondent had represented through his counsel that he was sober. His bank records were produced, and there were multiple purchases of alcohol from various liquor stores around town. There was an order August of 2023 specifically finding that my client Megan was promoting the relationship between the respondent and the children, and her concerns were legitimate. October of 23, the supervision of the visits continued with family therapy with Michelle Fairbank. And then in April of 24, the court approved a change of the family therapist to Amanda Brown. We were still doing supervised visits at that time with therapeutic visits, and then the respondent was allowed one unsupervised dinner. That continued, it's my understanding, until the person they were using for supervision of the visits moved. And then we were back in front of the court towards the end of 2024. That order was filed January 9th of 2025 for visitation to continue as directed by the family therapist. That kind of gets us up to today, Your Honor. Family therapy is ongoing and continuing with Amanda Brown. They're progressing. The visits that she recommends are agreeable to us. Like I said, the only issue that we have is that we would like breath testing to continue. The one thing I didn't touch on is that as a result of his DUI, the respondent had a restriction to ignition interlock, and that was sufficient for the schedule of visitation that they were using, that Mr. Gerber arrived to therapy and visits in his own vehicle, and the children were aware that he had to be sober to operate the vehicle with the interlock device installed. It's our understanding that his restriction ended earlier this month and he no longer has to have that interlock device in his vehicle. So we are asking that he return to using his personal breath testing device and producing those videos for Megan at the beginning and end of the visits with the children, just so that the children can be reassured that he's sober and is able to prove his sobriety. As far as that goes, I don't think the breath testing order that Judge Brown made was ever really rescinded. It was made unnecessary by the fact that the visits were supervised and therapeutic. But now that the visits are becoming unsupervised, I believe that order is still in place, and that it should be followed. We would just like the court to clarify that for us so that we understand what the rules are. But it's our position that the breath testing should continue because the girls are, they feel safer with that in place. One of the things that they're working on in counseling is building trust. And that gives them a lot of comfort when Mr. Gerber is able to prove his sobriety at the beginning and ending of their interactions.
Ms. O'Hara.
Thank you, Your Honor. Your Honor, I'm not going to go back and try to argue different things that have happened, but my client, Your Honor, has been sober for approximately 2 years, is my understanding. And I believe he has been having supervised visits for the last 2.5 years. I believe that began in looking back through the court file in August of 2022. He has attended treatment. He's successfully completed that. He's gone to AA meetings. He's been involved in individual therapy, and my understanding has been successfully discharged from that and is basically on an as-needed basis. He has done everything that is required of him. And Your Honor, my client doesn't necessarily, to get to the issue I think that's at hand, is the family therapist initially recommended on February 9th. She sent an email to myself and Ms. Park saying, "Hello, progress continues to be seen in counseling sessions between Brett and his daughters. Communication is improving and trust work continues to progress. It is my recommendation that visits return to twice each week when schedules allow, that all visits outside Brett's home be unsupervised, and supervised visits at Brett's home continue with the goal of these becoming unsupervised soon." And then, in talking with counsel, we're trying to figure, I was wondering if they would just agree to this to avoid a hearing, and then I'm told, well, no, now he needs to submit to breath tests, and then it's my understanding Ms. Park contacts the therapist and basically asks her to change the recommendation to now include breath tests. And my client doesn't have anything to hide. My understanding is he would testify, he remains sober, he remains clean and sober. That's not an issue, but the problem is that throughout this case, Your Honor, I mean, he's had supervised visits for 2.5 years, and it is just recent that progress has been made because we have a new family therapist with Amanda Brown. And it's my understanding that she has been pushing the girls to move forward, because when we had Michelle Fairbank as the family therapist, we couldn't get anywhere on anything. Everything just, there was no progress being made. We finally had an evidentiary hearing before Judge Brown, and he ordered a new family therapist. Then we had to wait to get in line to get in with her. And so there was some delay with that. But finally, as she's been entered in on this case, I think things have been progressing forward. And that's what we want. But Your Honor, my client doesn't have a problem necessarily with the breath test, but this can't just be an indefinite thing where he's been sober for all this time. He's done everything that's required of him, that he now has to continue to do breath tests indefinitely. And Your Honor, I don't even quite understand what the requirement would be if you're looking at this logically, because if he has visits at his home, they're supervised. So somebody else is there. The girls are 14 and 11. The oldest has a cell phone. The youngest has an iPod, is my understanding. They have ways to get a hold of somebody if they think dad's been drinking, or they think dad's under influence. Say, Dad, will you take a breath test? He'll take one. But to have this requirement that every time you do a visit now, we got to go back to, we're going backwards really, and not moving forward. And Your Honor, I disagree with counsel. That was an agreement that my client was going to do that early on. And then that got changed by Judge Brown after a hearing. And he says, now it's, now we're doing supervised visits at a therapeutic setting. That order was modified. It doesn't revert back to the old order, or my client should have significant parenting time if we're thinking in that way. So I think that order's been modified, and it doesn't just go back to that. But Your Honor, also, so the recommendation is visits 2 times a week. If they're at my client's home, they're supervised, which means somebody else is there. If they're not at my client's home, which means they're out in public, then they're unsupervised. So there's all these protections in place without overdoing this with all these breath tests. And if Your Honor is inclined to order that, which we don't think it's necessary with the way the visits are recommended, which my client is not pushing for more than what the therapist recommended. He really has never done that much at all, Your Honor. He's really been patient with this process. Michelle Fairbank told him repeatedly, just be patient, give the girls, I mean, he has done all of that. And then at some point, he's going to run out of time with these girls at the ages of 14, 11 to rebuild this relationship. And so, Your Honor, that's why we've been trying to push things to move forward. There's no allegation that my client's been drinking. There's no allegation that he has been under the influence of anything. There's really no basis, Your Honor, to request that he have to submit to breath tests, because he has shown that he's clean and sober. He's demonstrated that for really the last 2 years, and done everything required of him. So, Your Honor, if you're inclined to order that, which you don't think is necessary, then there needs to be an end to it. That, okay, after 30 days, he's demonstrated that he's clean and sober. The girls have trust in him. Then we got to move forward. And the girls need to understand that they can trust him. And I mean, at some point, Your Honor, I guess that's our concern, is the way this case has progressed, is when my client agrees to these things, it just lingers and lingers and lingers, and there's no progress forward. And I mean, when you look at this case, and he's had supervised visits for 2.5 years and been sober for 2 years, I mean, my client's been really patient, and we want to move forward. And so, Your Honor, we would request that, under the circumstances, there's no basis to request the breath test. But if you're inclined to do so, that there be a limit, and that we set this matter for review. Because, Your Honor, really, we would ask that this be reviewed in the next 30 to 45 days, with following the recommendation of 2 visits a week, unsupervised if it's in public, and supervised if it's at my client's home. And then after the 30 days, if everything's going well, we progress to all of it being unsupervised. We just like to get this thing moving forward. The oldest is in 8th grade. I mean, she's got really 4 years and she's off to college or whatever she's going to do. There's not a lot of time, and time is of the essence to my client to rebuild these relationships and to get visitation moving forward. But Your Honor, so again, Your Honor, I have some concern that the therapist has just changed her recommendation to add in breath tests at the last minute on a Friday after petitioner's counsel contacted her when it wasn't in her initial recommendation at all. And there's been no facts, Your Honor, really, it's all past history, nothing new that would support that type of restriction at this time. So, Your Honor, we believe there's safeguards in place that protect everyone. And again, you're not dealing with like really little kids here. You're dealing with a preteen and a teenager that have cell phones and access to contact people if they think something's wrong with dad. And obviously they're going to report it. And if they report, we think dad's been drinking, I mean, it's probably likely my client's visitation gets suspended. So, I mean, my client knows what's on the line and understands that. And so we would just ask that we move forward and move forward with the visits without the breath test. Thank you.
When did the ignition interlock device end?
Your Honor, my understanding was, I believe that was like last week, maybe. Is that right, Brett? Was that last Friday or Thursday?
Sorry, I missed the question.
I had asked when the ignition interlock device was no longer being used in the vehicle.
It was removed on Friday.
Okay. And were the girls aware of what the ignition interlock device was?
I believe so.
Okay. Okay, are the parties wanting to present evidence, proffers? How are you wanting to proceed at this time, Ms. Park?
Your Honor, I can proffer, and just by way of response to Ms. O'Hara's arguments, we do not have the therapist subpoenaed for today. She doesn't have a problem testifying. She's appeared at previous hearings, but we just didn't plan for her to testify today. So if the court wants to hear from the therapist, we would suggest rescheduling so that she could be included. But other than that, I would proffer.
Is that sufficient for you, Ms. O'Hara?
Yes, Your Honor. I thought I thought me and myself and Ms. Park had I think we understand what the issues are and what the recommendation of the therapist was. I think it's pretty straightforward.
Go ahead and proffer, Ms. Park.
Thank you, Your Honor. I don't have any objections to the recitation Ms. O'Hara gave of the email that Amanda Brown sent to counsel. However, after the exchange I had with Ms. O'Hara, where I asked for the breath testing to continue, she indicated that her client was resistant to that. So I reached out to Amanda Brown and asked her for her recommendation on whether the breath testing should continue. And she responded, "Hi, Carol, possibly the largest source of anxiety for the girls is the idea that Brett will relapse and begin drinking again. This has shown to be a consistent barrier as we work on trust building. Therefore, I would recommend that Brett follow through with the breath test to alleviate that stress on the relationships between Brett and the girls. If he takes the breath tests, there is proof, and if the girls get triggered, they are able to ground themselves in the facts." Your Honor, I disagree with the characterization that I asked her to change her recommendation. I simply asked her what her recommendation was regarding the breath tests. We are aware that the girls know what the interlock device was for. They have indicated to Megan more than once that they feel comfortable going into Mr. Gerber's vehicle because they know that interlock device is there and that they are aware that he can't operate it unless he's sober. They have also indicated not being comfortable without that device being there. So we do know that the reason that therapy is ongoing is because of their previous trauma. That trauma comes from Mr. Gerber's history of alcohol use, and they are in the process of working on that through therapy, and we don't feel that that we should hinder or get in the way of that process, but we also definitely don't feel that we should substitute our judgment for what the family therapist thinks. If her opinion is that the breath testing would help them work on trust building, that we think it should be in place. Your Honor, we have a history in this case of Mr. Gerber representing himself as sober to the court and that not being accurate. There is evidence from this year, Thanksgiving of 2024, November of 2024, where the girls had a FaceTime communication with Mr. Gerber and they believed that he was not sober. They reported that to their mother and to the therapist. They still do have those fears, and we believe it would be helpful for them to have the breath testing included, so that they have reassurance that he's sober. And, I recognize, Your Honor, that breath testing may not need to carry on forever, but at least at this stage, we need to be listening to what the girls and what the family therapist feel is appropriate for it to continue. The requirement is not that onerous, Your Honor. Mr. Gerber still should have the breath testing device that he purchased for his visits prior to those visits becoming therapeutic only. We're asking that he take those breath tests. They take just a few seconds. He videos himself taking the test. He texts it to Megan. And as the therapist pointed out, if the girls do have a fear or it's something that they're stressing about, there is proof that he's sober that they can reassure themselves with. I think the suggestion that because they have their own phones, that they should be able to protect themselves is pretty short-sighted, Your Honor. They are traumatized by the history of this case and Mr. Gerber's previous use of alcohol. And so to expect that they're going to be counted on to advocate for themselves in that instance is I don't think appropriate. And in fact, I think what they would do is just simply call my client over and over again and put her in the position of having to do something about their fears and anxiety while they're with Mr. Gerber. So we would ask the court to order the breath testing to continue until further notice. I mean, I'm not suggesting it carry on forever, but at least at this point, we don't want an end date put on it.
Ms. O'Hara.
Your Honor, I think I did some of my proffer in my initial argument, so I won't repeat what I've already stated, but Your Honor, it's my understanding that this allegation about Thanksgiving, and my client denies that, and it was discussed in therapy with the therapist, and he continued to have visits and they've been expanded since that time. So it doesn't really line up with the fact that they allege he's, not sober anymore or something to that effect, because his visitation has increased and the relationship has increased. And there's nothing in the report from the therapist to indicate that there's anything going backwards regarding their relationship. So Your Honor, Your Honor, we have heard, and I'm not trying to downplay anything going on with the kids, but we have heard over and over again the excuse for not taking steps forward is, oh, the kids are traumatized and we're going to go at their pace. And I understand that. And my client has been understanding of that. But there comes a point where we have to kind of move forward and push them to move forward. And my client hasn't done anything to displace their trust. I mean, he's done everything required of him. And so, again, I'm not saying that, he's opposed to doing this. It's just that at some point we have to have limits and move forward and not go backwards. So that's our position on that, Your Honor, is because my client doesn't necessarily have an issue with doing it. But we don't think it's necessary. And if it's necessary to instill trust in the children, then it should just be for a short time to show them, yes, he continues to be clean and sober, even after the interlock has been removed. But this isn't going to be long-term, and so that they are aware of that, and we're going to move forward, and they've got to have trust. And so that's what we would ask, Your Honor, because it just continues to be a reason they always go back to the past. Well, this, and this happened 2-3 years ago. And so that's why we can't move forward now. And at some point, my client's done everything he can. We just have to move forward. So that's our position on that, Your Honor. Thank you.
You both indicated that when the girls visit his house, it has to be supervised. When he's visiting with the girls outside his house, it does not have to be supervised. What was the rationale between supervision at home, but not if you're away from home?
Your Honor, I can attempt that. Obviously I have not questioned the therapist about that, but my understanding is that the girls are particularly traumatized by being in Mr. Gerber's home. They have had multiple reports of feeling unsafe in his home, of witnessing him passed out in his home and not feeling like they had any alternative to get out or become safe from that situation. So it's my understanding that they still deal with quite a bit of trauma from the physical experience of being in his home. They talk about the smell. They talk about just their reactions to being in his home. So I think it has been quite a while since they've had a visit inside his home. And I think that is probably the reason for those visits to be supervised, so that the girls have someone there that they can, another adult there to feel safe.
You indicated that the supervisor, the visitation supervisor has changed or left.
Your Honor, they started out with one supervisor. She moved away, and they have now been using a new supervisor. She's been supervising visits for a few months.
Couple months.
This is a paid third-party supervisor or a volunteer third-party supervisor, but it's a third-party supervisor.
That's right.
It's
Yeah, I
not,
believe my client pays for that.
it's not like a significant other that he has staying in the home.
Correct. It's not.
Okay.
Your Honor, I also, to follow up on the answer, I understood that there has been visits at my client's home recently. That was my understanding that has occurred.
And that was my error, Your Honor. It was supervised.
I know that at least the last one for sure. They watched the Chiefs Buffalo game at the home, according to these notes that you sent me in Exhibit A. When the parties have worked out the amount of visitation, that's not an issue at this time.
No, Your Honor, we don't have any problem with the parameters outlined by the therapist.
You know what the plan is to go to unsupervised visitation in the home? What's the therapist's plan for that?
We don't know.
Okay. Anything further, Ms. Park?
I don't believe so, Your Honor.
Anything further, Ms. O'Hara?
Your Honor, the only other issue that I think had been discussed at some point was my client's been paying for these supervised visits for a long period of time. And Judge Brown had initially said because of his child support obligation being low that he would pay. Then that's been revisited and recalculated per the child support guidelines. And if we're going to continue indefinitely with supervised visits, we would ask that both parties have a stake in that and at least pay equally for the supervised visits going forward.
If the reason for the supervision in the home is to ensure that there has been no alcohol use going on and that he is sober. Yeah. And I certainly don't want to overstep the therapist and take away from what the therapist is doing. But it would seem to me that the party should check with the therapist. And see if he's ready to progress to where he can take the breath test at the beginning of the visit and at the end of the visit. Send it not only to the respondent, but does he have any objection to showing the girls? And that way it puts their minds at ease right from the get-go of the visit that he is sober. And then he can maintain his visitation And that could be unsupervised as long as he takes the test at the beginning and then at the test at the end to show the girls he's not drinking, alleviate their concerns. And that would seem to me to be a good way to alleviate the need for a third party to be in the home supervising.
Your Honor, I would think my client would be okay with that.
Ms. Park?
Your Honor, I don't want to speak for the counselor. Her email of February 9th indicates that supervised visits at Brett's home continue with the goal of these becoming unsupervised soon. So I don't know what soon means in her mind, but she apparently had some benchmark that she was working towards, under which she would recommend that they be unsupervised. So I don't know that I can, my client's position is that we do what the therapist recommends. We do think that the girls would be reassured by seeing the breath test, so we have no objection to that. But as far as removing the supervision while they're in his home, I would defer to the therapist on that.
From what the parties have explained to me, it seems that the third party person at the home was to ensure he was not drinking. If he's taking the breath test and showing the girls and Megan that he does not have alcohol on board at the beginning of the visitation, and then he does that again at the end of the visitation, I don't know why we would need a third party in there. Can the parties check with the therapist and see if that is an appropriate way to get to unsupervised? And then we could do that for a period of time until it has alleviated the girls' fears. And I understand it might be, I don't know what Mr. Gerber's reluctance to alleviate the girls' fears are. I would think that they would make visitation much better if they alleviated that fear right at the get-go, saying, hey, Dad has not been drinking. He can proudly tell them it's been 2.5, however long it's been since he has been drinking, and alleviate their concerns and have a good visitation. Till I hear from the therapist, if the parties believe it's necessary for me to hear from the therapist, I'm not going to countermand her order. But I am going to ask the parties to check with the therapist and see if that would alleviate her concern, because I think that alleviates the girls' concerns. And that seems to me the next natural progression is to eliminate that third person in the house with the assurance to the girls that he's not drinking. And he can do that by showing him the breath test. Is it a PBT or something like that?
Yes, Your Honor.
And does Mr. Gerber still have his device?
Yes, I believe so, Your Honor.
And is it one that gives a digital readout?
I believe so, yes.
So if the therapist is agreeable, the court is certainly agreeable to doing that in lieu of having a third person in there supervising. That makes it more uncomfortable for everybody.
That's fine with us, Your Honor.
That's fine, Your Honor.
Yeah. And then at a point when the parties agree, he can go to just showing at the beginning. And eventually you can work to where he doesn't need to show the girls and they'll just trust that he's not using. But if he wants to put the girls at ease right from the get-go at the visit, that's the best way to do it. Just to show him he's got no alcohol on board. And they can all move past that issue and have a good visit. Any objection to proceeding that way, Ms. Park?
No, Your Honor, that's fine with us.
Ms. O'Hara?
No, Your Honor.
Okay. So check with Amanda Brown and see if she is agreeable to that. If she has some good reason why we shouldn't do it that way, I will defer to her to leave it in place as is till I can hear from her. And the parties can put her in front of the court. But if she's agreeable, that seems to me like the next step towards going to unsupervised visits.
So, Your Honor, if I understand, if she doesn't agree to that or recommend that, then we follow her recommendation, then what do we do on the breath test?
Well, he'll need to take the breath test. I'm still ordering the breath test at the beginning and the end of the visit until we have a further hearing. If she does not agree to that, let's put her on and let's find out why. If she's agreeable, then he can do the breath test at the beginning and the end of the visitation, set the girls' minds at ease, set Miss Geist's mind at ease, and they can have a good visitation. And the girls are now 14 and 11, and so I think they have a good understanding. They probably have a better understanding than we give them credit for, of knowing the situation. And if that is what puts their minds at ease to have a good visit with dad, then that's what we should do. And I think that's better than putting the girls in a position where they have to be the police looking for signs and symptoms of alcohol use during the visit. That puts their minds at ease from the get-go, and they don't have to worry about that. Obviously, Brinley's 14, Lola's 11. If they have a concern, they can certainly express that to Ms. Geist. And that can be dealt with. But do the breath test at the beginning and the end, show the girls, show Ms. Geist. That should alleviate everybody's concerns. And then we can revisit the issue. Either the parties can agree to taper that off, or we can revisit the issue as we've had a series of visitations where he continues to show he's not drinking.
Again,
Your Honor, do we need to, if the therapist doesn't want to do that, then do we need to set it for hearing? How do we want us to proceed?
Yeah, then you can notify the court.
Okay.
And we can have a hearing, and I can hear from the therapist and find out what her concerns are.
Your Honor, if she's agreeable to that, then do we just set a review date?
If she's agreeable to that, then we'll proceed that way, and the parties can set a review date down the road.
And how far out do we need to have the review then?
I would say 3 months right before the end of school so that you can get your summer in place. Is the oldest an 8th grader right now?
yes.
Yes.
Oh, so she's got high school coming up. That's a whole new experience for the parents. So if she's agreeable, do it that way and alleviate the need for a third person to be there, and then we can review this towards the end of the school year.
Sounds good.
If she doesn't agree with that approach, then let's hear from her. The parties can schedule a hearing much sooner.
Okay.
Okay?
That works.
Anything further today?
Not from us.
No, Your Honor. Thank you.
Whose turn is it to journalize?
Probably mine.
I was gonna volunteer her, but I wasn't for sure.
I see the order file January 9th is Miss O'Hara had done that journal entry. But I didn't know what your history was prior to that journal entry, so.
I can do it, Your Honor.
Ms. Park, you do the journal entry.
Thank you, Judge.
Okay? Anything further for the record today, Ms. Park?
No, Your Honor.
Anything further for the record today, Miss O'Hara?
No, Your Honor. Thank you.
Thank you all.